The
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals, brought to you by the Center for Judicial Engagement at the Institute for Justice. I am your guest host this week. My name is Anthony Sanders. I am director of the Center for Judicial Engagement. And with me are two eminent lawyers. One of them is Bob McNamara, senior attorney at the Institute for Justice, who you may have heard on this podcast before. And also joining us, a special guest, Professor Joe Mead, who's a professor in Cleveland, Ohio, and is also counsel for the ACLU of Ohio. Joe, welcome to Short Circuit.
Thank you.
Well, we're going to start things off with Bob, who has this interesting case from the Sixth Circuit, who said, I believe, that constitutionally, kids in Detroit need an education. Can you tell us about that, Bob?
Yes. So we have a new fundamental right, which doesn't happen very often. But coming out of the Sixth Circuit, we have Gary B. v. Whitmer, which is 85 pages of closely reasoned legal analysis, which I will summarize in about 2 minutes by being deeply unfair. A group of plaintiffs, children who are in Detroit public schools, have brought this lawsuit challenging the conditions in Detroit public schools, which from the allegations in the complaint sound like an absolute nightmare. Not just sort of the things one would expect, teachers are unqualified, kids aren't learning, classrooms are overcrowded, but entire schools lack water that is fit for human consumption. Just genuinely astonishing allegations of just utterly decrepit failures of public administration. And they've brought suit under the 14th Amendment, saying this violates either the Equal Protection or the Due Process Clause of the 14th Amendment. And it's an exciting case, but it is unfortunately a case that's mostly about whether they sufficiently pled things in their complaint, which is the least exciting way to talk about constitutional law. But the court looks at their equal protection claim, and their equal protection claim basically is, the state of Michigan has intermittently taken over Detroit schools against the will of the local people and politicians in Detroit and has administered this monstrosity. And the court says, yeah, but nothing in the complaint really says what the state is doing that's causing this. Like, what specifically is the state doing that makes Detroit schools terrible and schools in Ann Arbor not terrible? And without that allegation, we can't really say that this is an equal protection violation because you don't have the clear allegation of, that the state is funneling kids of one race into these schools and kids of another race into those schools, and those schools are good and these schools are bad. And without that allegation, the Sixth Circuit just kind of throws up its hands and says, I don't know what you want us to do. You didn't give us enough facts, and maybe you should be allowed to amend your complaint, but we don't have that here. And then it turns to the Due Process Clause. And the plaintiffs say they actually have two due process claims. One is that they have a negative right to not be forced to go to school. Michigan law compels attendance at public schools. And, the Supreme Court has never really grappled with why compulsory attendance of schools is okay. Like, it seems like a pretty obvious background principle that we all have the right not to be ordered to go places. And it seems equally kind of obvious that compulsory attendance at school is okay, despite that principle, because when kids go to school, they get educated. And, that's a trade-off the courts are willing to let the government make. And the crux of the argument here is if the school is a travesty that lacks potable water, then perhaps, just perhaps, I have the right not to have to go there. And the court sort of walks through what that claim would look like, and then once again says, yeah, but you didn't plead that in your complaint. So we're not going to require the government to answer for that. And then it turns on to where the real action is, and where I expect there's going to be further litigation in this case, by recognizing under the 14th Amendment a fundamental positive right to receive an education that gives you, I guess, a shot at becoming literate, which the Detroit public schools currently do not. And the difficulty with this, kind of for those who are not immersed in the jurisprudence of fundamental rights, is that the general consensus is that the modern Supreme Court has been absurdly hostile to the discovery of new fundamental rights. A fundamental right has to be two things under a case called Glucksberg. It has to be, first, you have to carefully describe the right, and then you have to show that the right is deeply rooted in American history and tradition. And Randy Barnett calls this the Glucksberg two-step, because any right that you can find deeply rooted in American history and tradition, you're probably not describing narrowly enough.
And sorry to interrupt, Bob, but Do you know of a court that's ever seriously looked at the Glucksberg two-step for a positive right before? I mean, let alone recognized a fundamental right that's positive.
So the court has generally spoken about and has frequently rejected claims of positive rights under the 14th Amendment, that the 14th Amendment is about restraining government and it's about equality of the benefits the government chooses to provide. But generally speaking, and the court has specifically said, for example, you don't have a positive right to police protection. What you have is a right to equal police protection, but the government doesn't violate the Constitution if your town decides not to have a police department. And what the panel does with that is, I think, an interesting move, though not a move I really think is ultimately persuasive, is they just say education is different. Education is different because state provision of education is so pervasive that there really isn't anything analogous to that, that people expect the state to provide education. The state's control of education so pervades American society that therefore you can have a fundamental positive right to education that can help you lead to literacy.
Don't they expect police protection too, though? That's what I really didn't understand about that.
I mean, that's my thing with this opinion, right? Is like, yes, there's a lot of government provision of education, but also I can educate my children myself. I can choose to send them to a private school. Private schools aren't illegal. I actually can't round up my buddies and go, like, take my stuff back from someone who I allege has stolen it. Like, then I'm a street gang. It seems strange to say the state control of education is more pervasive than the state control of violence. And if you don't have a positive right to protection from violence, I'm not really sure how you can say that education is different. But perhaps I'm wrong. Two-thirds of a Sixth Circuit panel thinks I'm wrong, and I've certainly been wrong about things before.
Yeah, what I found interesting about the opinion is that rather than cite a affirmative Supreme Court case that supports this right, because this has never been, the right to education or right to literacy, however you describe it, has never been articulated by another court, they point to several times that the Supreme Court reserved rejecting this particular right, or applied it in narrow ways that essentially embody an anti-discrimination principle, right? So they cite to Brown versus Board of Education, they cite to the Texas school cases where Texas was excluding undocumented immigrants. None of these, though, would get you quite as far as the Sixth Circuit went.
No, you have to expect that sort of everyone else on the Sixth Circuit is watching this. Kind of in my head, there's a big red siren in Judge Sutton's chambers that go off when someone recognizes a new fundamental right in the Sixth Circuit. And so you have to expect there's going to be further litigation and an en banc petition to sort of drill this down. But it strikes me as sort of a well-intentioned effort, a noble effort, but the panel's reasoning, another thing they do, you're right, that they don't cite to any case adopting this, and to the extent they point to Supreme Court case law, it seems just not quite to fit. Like, one of the strong things they have to show that the Supreme Court has recognized positive rights under the Due Process Clause is Obergefell. Obergefell says that the right to marry is a fundamental right under the Due Process Clause. And it does say that, but I just have a hard time believing that taking that sentence out of context, that's what the opinion means. That Obergefell stands for the proposition that Obergefell could stand for the proposition that if Oklahoma just stopped issuing marriage license altogether, that it would violate the principle in Obergefell. Obergefell, I think, is fundamentally an equality case, not the government has an affirmative obligation to provide you with this benefit case.
And in terms of where this court case goes, the opinion kind of intimates, well, it doesn't intimate, it says that the defendants really aren't defending the case other than two board members, who I'm guessing don't make up a majority. So how could the case go en banc at this point? Would someone need to intervene, or what's your thought about that?
I mean, circuits can take things en banc sua sponte, and if there is in fact a big red siren in certain judges' chambers, that it may have gone off and there may already be internal debate. Or it could be no one says anything and the case just kind of gets quietly remanded for the complaint to be amended to fix these things the panel pointed out that it wanted fixed, and we don't hear anything else out of this case for another 2 years. And sometimes you get decisions that just sort of pop up and you think, that's maybe questionable reasoning, but just there is no court in a position to say anything about it for a while, and it just kind of floats along.
Well, from the intractable problem of public schools in Detroit, let's turn now to something very current, and we have someone here who knows a lot about it, and that's this next case concerning prisoners and COVID-19 in Ohio. So take it away, Joe.
All right, thanks. Yeah, so we all know that coronavirus is wreaking havoc across our society in all kinds of different levels. The danger is particularly acute in prisons and in detention centers because these congregate settings like cruise ships, nursing homes, and so on, they pack people together in a way that is it dramatically facilitates the transmission of disease. So once one person in one of these settings gets it, then pretty much everyone gets it. In detention centers, especially low security detention centers, it's virtually impossible to prevent the spread of disease. Especially something as contagious as the coronavirus. Oftentimes 100, 200 people are placed in a single room for their primary sleeping habitat. They have cubicles, perhaps, where beds are kept 2, 3, 4 feet apart, so they're not maintaining 6 feet social distancing. Access to soap may be limited. There are limited bathrooms and shower facilities, and so on and so on and so on. So prisons pose a acute risk to people who are both living there, but also working there and in the surrounding community. This is demonstrated by some prisons in Ohio and Michigan have 100% or 90% of the prisoners already infected with COVID-19. All right, so I'm hitting this point hard because I want to make it clear that this is a real problem, and it's not just something that's the same in prison and out. Prisons are uniquely dangerous. And that's kind of the theory by a series of lawsuits that have been filed seeking to either force the release or at least force some major restructuring of prisons based on the response to the coronavirus. So one case that I'm working on involves the federal prison in Elkton, which is in eastern Ohio. So in Elkton has more people have died in Elkton from coronavirus than in any other federal prison. And so we filed a class action. There are 2,400 residents. This is a low security prison. We filed a class action basically asking a court to take some pretty drastic action to reduce the population to allow social distancing. Our theory is under the Eighth Amendment, right? So that we've been talking about when is there a positive right. The Eighth Amendment says that the state can't engage in cruel and unusual punishment. And the Supreme Court has said failure to protect prisoners from an undue risk of harm it can be cruel and unusual punishment if the decision not to protect them is based on deliberate indifference. And so for the school case, for example, prisoners, once you're incarcerated, you don't have the ability to go get food yourself or to seek your own medical care or even to protect yourself from violence from others or infection. And so that's why the Constitution imposes a duty of care. It's not a very high duty of care, but there is a duty of care.
Similar, you might say, to once you force kids to go to school, you should be doing some kind of education for them, which was maybe the negative rights aspect of that other case.
Yeah, I mean, so maybe that would be the logic there. It does startle people sometimes when you tell them the only population in the country that has a constitutional right to health care are prisoners, because they don't have the ability that you or I might have to pay for our own care. Or seek it in some other way.
Not even pay for it, but just go anywhere.
Yeah,
I mean, there
exactly.
are actually cases about the right to medical care, the right to rescue, where what the government does is I'm drowning, and the government actively prevents someone from coming and saving me from drowning. In a prison, like the government's preventing anyone from coming in and saving you from drowning.
Right. Yeah, and so we. The two things you need to show in a deliberate indifference claim is not only that there's an objectively serious risk, but that the government is choosing, essentially, under some measure of culpability, not to provide you protection from that risk. And so in our case, the district judge agreed with us that there was deliberate indifference and ordered the release of about a third of the population. And these were people who were medically vulnerable under CDC guidelines as being particularly at risk of having negative health outcomes from the virus. And so that's up on appeal in the Sixth Circuit.
So one thing that the judge seemed to not have too much patience for in the government's argument is exactly where all these people are going to go. And the judge seemed to think that there are ways, whether it's inside the prison, in a different facility, maybe they have them in care of someone outside of the prison system. There are ways to distance these people and yet not just, put them on the street, so to speak. I was a little surprised how the judge didn't think it was necessary to get into those details. Has that been usual in these kinds of litigation, or is that just not something that needs to be dealt with in this type of opinion?
I think it's going to be dealt with going forward. That's certainly going to be the next stage of litigation, is figuring out exactly the logistics of it. Who qualifies? What does that look like? How quickly does the government need to act? Can they just create a new facility with all the same dangers and hold them there? That would not seem consistent with the spirit of the judge's order, but those are things we're going to have to figure out. But I would note that there's a parallel between that question and the Detroit school case, which is that the Sixth Circuit articulated this right, and it kept saying, well, there are a lot of details to fill in. We'll remand it to the district judge to figure out how to actually implement this. And so, sometimes you can articulate a right, but then how it gets implemented becomes the significance of it.
So I have a super nerdy question about your case, which I'm going to ask because I think that is the spirit of this podcast. So I don't know a lot about prison litigation, but as I understand it, there are basically two sorts of claims a prisoner can bring. Like, one is a petition for habeas corpus where the prisoner says, you can't hold me. I didn't do anything wrong. You have to let me out. And the other is more like a Section 1983 claim where the prisoner says, you can't hold me like this. Like, you can keep me in prison, but I'm being beaten. They're not giving me any food. You have to hold me in different conditions. And this case seems like both, because you are saying you can't hold me, you have to let me out, but you're also saying, like, when you let me out, if you have like a halfway house or you have some other prison where I can be socially distanced, you can put me there. And the district court's opinion mentions this, but doesn't really point to any cases that dictate which kind of claim you have to bring. Why did you bring this as a habeas petition? Like, was that hotly fought on the front end, or are there actually a bunch of these cases I'm not familiar with and it's well settled that this has to be habeas?
We brought it as both.
Okay.
All right. And that has been the model that most recent challenges. There have been dozens, if not over 100 cases in the last 3-4 weeks challenging prison conditions. And usually it's a mix. The circuits have differed in in terms of what claims are cognizable under habeas, because as you point out, typically if you're complaining about prison conditions like, oh, they didn't bring me to the doctor when I was sick, that is a 1983 claim, not a habeas claim. But at the same time, if you're seeking someone's release, that is like classic habeas. And since we're seeking both, as you point out, the courts have gone all over trying to figure out how this new situation fits in these old boxes.
And so you did what lawyers always do, which is just say, the courts have been unclear about which box to use, so I've brought you all the boxes, Your Honor. I'll take the rest home with me.
We're sure it fits in at least one box, probably both. So we'll let the courts figure out which box is correct. But I mean, personally, I'm a big fan of habeas. It's such a powerful tool. It has such a historic pedigree. The Great Writ. People always say poetic things about it. Certainly, it's not. This isn't the classic case where I was detained by an officer without trial for an undue period of time, or the habeas we've come to appreciate in modern time is the state convicted me under some process that was unconstitutional. But just because it's a different type of claim doesn't make it a bad one. It's just something we haven't had a situation like this before.
Joe, this is a question that goes a bit outside of this particular opinion, but I wonder if you can enlighten us on it. One, some people probably hearing about prisoner litigation and COVID-19 think, that may be a very bad thing, but it's really just a prisoner rights issue. It doesn't affect the larger community. I wonder if you could say, in the context of this Elkton prison, but others also, how how many people go in and out of this prison? People, of course, do actually finish their prison terms and leave at jails. There's a huge amount of turnover because people are often just in jails for a few days. There's also staff that goes in and out of the prison. So how does all that have an impact on the spread of this disease, given that it sounds like that the prison is basically in a huge petri dish, and that petri dish then can spill outside of its boundaries?
Yeah, I mean, that's a huge concern with these cases. One Ohio State prison, they traced, so 90+% of the Ohio State prison became infected with COVID, and they traced that to the surrounding community, that ultimately it wasn't just staying in the prison. The corrections officers and the staff go home at night. If somebody gets sick, right, and they're at risk of dying, or if they need emergency care, they have to be taken to the community hospital, where that poses a risk of transmission. So it's not that these are contained environments. Now, most prisons have limited visits from family or even legal counsel. It's all done by phone now, or nothing. And so that certainly has helped keep prison populations separate in terms of infection from the surrounding community. But we also know that that's just from empirical work. People have looked at this, and from the anecdotal experience of this virus, what happens in prison doesn't stay in prison.
And it's an interesting thing I've noticed from the outside in the politics of it, that in some states, it seems like actually the corrections officers' unions are lining up right alongside the prisoners. Really, it seems like the usual dynamic is prisoners say, we're being treated badly, and the correctional officers say, no, you're being treated great, we're doing everything fine. And here you have prisoners coming forward saying, this is really dangerous, and the unions are right there saying, absolutely, like, we don't want to be here either.
Yeah, no, absolutely. We've seen that to some extent in Elkton, and certainly in other federal prisons and state prisons. Yeah, they understand the risks, and they understand that if the state or federal government doesn't do more to protect against infection within prisons, they are also at risk, and then their families are at risk, and that certainly is startling. A lot of people there are stories of people quitting or calling in sick and just not wanting to come in anymore. So that reduces the staff, it reduces the services, it reduces reduces the entire effectiveness, I guess, of the correction system.
And Joe, what's the timeline on this? I'm guessing that's going to be a pretty quick appeal to the Sixth Circuit.
Yep, the government appealed on Monday, so a week ago, and we're litigating a motion to stay right now. We dealt with the Sixth Circuit rejected the government's request for an immediate, one-day stay, but now we're litigating a longer stay. So yeah, it'll happen pretty quickly. But that's, part of our argument is that time is of the essence. You got to release people immediately, and the government's like, well, no, we don't want to do that, right? So.
Well, good luck to Joe in that future litigation. Good luck to Bob, of course, in all of his cases. And good luck to all of you. This concludes the show. Thank you for listening to Short Circuit. And until next time, keep reading the Federal Courts of Appeals.